this case at the appellate court level. So Annette's been directly involved in the legal proceedings that led up to the decision a few weeks back. We've got Larry Rosen sitting next to her. Now Larry, for those of you who don't know him, basically wrote the book on open source licensing. So all the different open source licenses out there, the regime that is the open source initiative, Larry is the guy that knows all there is to know about open source licensing, and he's with Rosenlaw and Einschlag. And then we have Pam Samuelson sitting next to Larry. Pam is a distinguished professor at UC Berkeley, and she wrote one of the amicus briefs in the case on behalf of intellectual property professors. And of course, well, I don't want to say of course, but that amicus brief was in favor of non-copyrighted APIs. And Mike Linksvayer, who's a senior fellow at Creative Commons. And one of the reasons that I've got some representation from both the open source community and the Creative Commons community is, well, okay, if APIs are copyrightable, what next? Do you use Creative Commons? Do you use a commons of some sort? Do you use open source? Do you not do either of those things? So we'll have a very vibrant conversation as we go through this. If you have questions, I ask that you write those questions down, keep them handy, because we'll have an opportunity to ask those questions. So we'll dive right into the big elephant in the room and start that off. Should APIs be copyrightable? And I'll just ask each of our panelists to address that question. I'll start off with you, Annette, since we know that your answer is yes, but we'll ask you why.
Well, so I want to stop there for a moment and say API can mean a lot of things. And it's quite clear that software is copyrightable, and that the Copyright Act has a very broad definition of software. And that everyone in this room who writes software and hopes to be rewarded for that effort should believe that software is copyrightable. In the Oracle v. Google case, the code that is at issue. Oops, did you turn me off? Already? In the Oracle v. Google case, the code that is at issue cannot be distinguished from other kinds of code that we think is, should be, and absolutely must be copyrightable in order for our economy to continue having as one of its major economic engines software. And so I'm here to say the rules for copyrightability are no different for whatever you might call an API than they are for any other kind of work that is subject to copyright. So for example, in music, we don't say there's a category of music that is uncopyrightable per se. We don't decide, oops, waltzes, 1, 2, 3 beat, not copyrightable. We don't look at poetry and say, haiku, 575, oh, not copyrightable. We don't look at art and say abstract expressionism, that's pretty basic, not copyrightable. Instead, there's a set of rules that applies across the board. And when you apply that set of rules fairly, in this case, what you found was, one, everybody agreed that it was creative and expressive. Even Google and its witnesses and its experts agreed. The APIs at issue here were creative and expressive. And then you look and see, you ask the question, at the time they were made, was that the only way to do it? And everybody agreed again. The answer to that question is no. That means it's copyrightable. And you all want it to be copyrightable because of the work that you're doing that you may need to protect as well. So I'm here to say the same rules should apply to something that might be called an API. That's a very broad term. It can mean a lot of things. The same rules should apply to APIs that apply to any other kind of software. There's no magic line to be drawn there. And that's the way you should want it in order to make sure that you get rewarded for your work.
All right.
Yeah, I think the problem in this case stems from the fact that the court didn't understand, and maybe it's because the attorneys didn't explain to the court what an API really is. An API, they said at the second line of the decision, the parties have often referred to these groups of computer programs individually or collectively as application programming interfaces or API. Well, if you go to the real authority on what an API is, which is Wikipedia, and you will discover that an API is a specification. It's not code. Now, it may be that in order to write the specification, you have to put code in it. For example, the specification for HTML5, which comes out of W3C, has code embedded in the spec. But it is still a specification. And therefore, how it is to be used is not as an expression, but as a function. That's what its intention is. More to the point, Oracle and Google both understand this. They have been working at W3C and Oasis and IETF, and at least one of them working with me in the Open Web Foundation, to try to make sure that even though in some sense it is copyrightable, it also is usable and intended to be used, and specifically intended to be an industry standard. We're not just talking about Java because it's a cup of coffee. We're talking about Java because it is a language that is specified to operate in a particular way. And as such, the requirements for it and the copyright attitudes toward it have to change. Let me give you an example of an earlier court case, not directly on point, but similar. About 12 years ago, the Veek case came out. In the Fifth Circuit, it went to a decision by the Fifth Circuit, then it went to an en banc decision, and then it went up to the Supreme Court, which refused to hear it. And the Veek case related to the licensing or the use of copyrightable building codes. Now, everyone understands if you want to build a house in the United States, you better honor the building codes, or you won't get permission to build it. So the question came up, is it copyrightable or not? And the answer is, according to the court, yes, it's copyrightable, we don't care. But with respect to its use as a building code, it loses its copyright. And I think that's what we've got to teach the court about. And then when we come back, I'm going to say something more about the fair use argument, because I think the fair use argument, which the court said we need to deal with, when you look at fair use for a specification, there is no question in my mind but that Google and the rest of the world is making fair use of the Java specifications.
I'm going to get to respond to some of this, right?
You sure are. And so, and I'll just point out that the case, a part of the case is remanded back to the circuit court on the issue of fair use. And we're talking about is basically defining what fair use is in the context of an API. And that's a big question because some of us, like a journalist, knows what fair use is in terms of the text that you put into, that you take from like New York Times and put into your own article. But in the case of an API, where that could be just one line of code, it's just not clear on what fair use could possibly be. Larry, I was wondering one thing about open source and APIs. There are several API organizations in the industry, OpenStack being one of them, that say our APIs are open source. Doesn't that automatically imply that the APIs are copyrighted?
I'm not going to argue.
Since open source is a copyright regime.
I'm not going to argue with the court. I think they were probably right in saying that the original work that was done by Oracle or by some in developing the specifications, writing them down, as you said, they had thousands of choices of how they could do it. They picked some particular choices. At that point, it was copyrighted as far as I knew. I wasn't angry.
I'm so glad we can agree on that.
We can agree on it. But that doesn't mean that you have a copyright for all purposes or for all times. It has to do with what you say. And the fact is that Sun and then Oracle have for years licensed, released, developed the Java community process, which according to Sun and Oracle's own industry experts that I work with every day, they insist that those kinds of specifications have to be available for the implementation of open source software. Now, it isn't clear that the licenses are written right to do that, and that's why we set up the Open Web Foundation. But I don't want to go too far off with what kind of licenses you should use, but I would suggest that Oracle and Sun have for years given us a license to Java and its APIs. And for them at this point to make a claim about the copyrightability of header files is, I think, a little bit outrageous.
Okay. I'm going to come over to Pam. The reason I'm waiting is so if you want an opportunity to respond, but let's get everybody here
Of
so
course,
you can respond and advocate. And again, I don't want to spend too much time on copyrightability questions because there's so much more to cover. So Pam.
So computer programs aren't like poems. They're not like music. They have a functionality that makes copyright a particularly strange law to be applied to them. So nobody these days would argue that software isn't copyrightable. For sure it is. It protects code, it protects possibly some structure, sequence, and organization of programs, but that term, structure, sequence, and organization, which comes up in the context of the API copyrightability in this case, has been discredited as a kind of a way of thinking about what copyright protects in computer programs, because it doesn't help you to distinguish between structure that really copyright should apply to and functionality which it should not apply to. So there is a provision in U.S. copyright law that says that you can't get copyright protection for a process, procedure, system, or method of operation. And a big question that's issue in this case is what those words mean. And it's important to understand that Congress put those words in the statute specifically so that the scope of copyright protection in computer programs would not be too broad. And there have been a number of decisions interpreting what 102B process, procedure, system, method of operation means in the context of software. And two of the decisions of the Ninth Circuit Court of Appeals, which is the Court of Appeals here in California and on the West Coast, says that the functional requirements for achieving compatibility, which we all understand to be APIs, are part of what's unprotectable by copyright law under this provision. And it's been settled law since 1992 that the functional requirements for achieving compatibility are beyond the scope of copyright protection that is available to programs. And this case essentially takes us back to the mid-1980s when the copyrightability of APIs had seemed to be a plausible interpretation of the statute, but then both the Second Circuit Court of Appeals in the East and also the Ninth Circuit out here in the West basically said no. I think not only did Judge O'Malley, who wrote this Oracle decision, not know what an API is, she don't know copyright law either, and so this is the worst decision out of a federal appellate court since the Whalen versus Jassel case in 1986, and that's saying something.
I just want to say, I would rather you tell us what you really think. Okay.
So I'm not going to talk directly about the case. I'm more interested in what we should do from here. And to make clear, Creative Commons offers licenses like open source that operate in the same way as open source licenses. They grant permission in advance around things that copyright restricts by default. Even though those are the tools that we offer, and so therefore copyright makes us necessary in a way. We think that licenses can't accomplish everything, that user rights and innovation and competition require a big default space for public domain and other exceptions and limitations that are false. So Creative Commons supports copyright reform and increasing the default regime on public domain. And in the space of APIs, although this isn't really Creative Commons' main area, that would mean that, for instance, independent implementations of an API should never require permission from the creator, the designer of the API, or previous implementers, or other people who happens to acquire the rights. I think it's really important to understand what the different sorts of things that an API consists of, both in order to answer the kind of copyrightable question that has been discussed, as well as what kind of private solutions can be applied, whether public licenses or standard body regimes. And so, I mean, those things include the actual specification text, implementation, the client's implementation, the server implementation, documentation. We're going to get broader in thinking about how an API comments can be created and go beyond that. Think about the data that's provided through the API, metadata about the API, for example, API registries. All of those things are things that copyright and/or patent may or may not apply to. We can think about the right instruments to create a permission-free space that's necessary for competition. I would encourage this community to think about really creating a permission-free space for innovation. The alternative is really inviting down later regulation that's much more messy in order to protect consumers from anti-competitive behavior, basically. And finally, I want to challenge the statements that without copyright, the software economy as we know it would go away and we should all be for strong copyright for software. That's just not true. And that's very evident in the API space, which is largely about providing services. And trade secret is still very pertinent. So it's just not true that strong copyright is necessary for, especially for software in general, but especially this community and the economy to thrive. You should be very suspect of regimes that are fundamentally protectionist and are going to wreck the competitiveness of the industry and, again, make other kinds of regulation come down the pipe.
Okay, so you asked for an opportunity to respond. I'll give that to you. And I'm also going to ask you that when you're responding to talk a little bit about how, Oracle obviously contested this very vociferously and how it has prevailed at the appellate court level. What risk was mitigated as a result of this, or what, why was this in Oracle's best interest?
So let me say this. I represent a lot of parties and a lot of different copyright litigation, and so I want to say that the views expressed here this morning are my own personal views. Nonetheless, they are very strongly held. What was at risk in this case was open source as you know it, and the ability to have a Creative Commons or an open source regime. Because without copyright, you cannot enforce your choice to make something open. You cannot enforce others granting back their participation in that open source framework of any kind without copyright. So if you want open source, you must have copyright, or you will have no way to enforce it. What was at stake in this case was the fundamental principle on which the Java platform was created and for which it was so revolutionary. Write once, run anywhere. Write once, run anywhere. Do programs that were written for Android run on the Java virtual machine? No, they do not. Larry said, this has always been made freely available with licensing. It was made freely available with licensing on the same terms to Google. They didn't want compatibility. They wanted to fork the code and make it proprietary. They didn't want it to be interoperable, and it's not. Google perceived an existential threat in the mobile space, and it moved rapidly and with dispatch to address that threat. It copied 7,000 lines of API code, it copied other code, and it released a product that didn't meet the licensing terms upon which the Java platform had always been made available. So what was at stake and what is at stake today is the very notion that you can have a choice about open source and be able to enforce it. Because without copyright, you can't do that. And I would just like to say a little bit in response to Professor Samuelson's characterization of the law. What Oracle did when it sued Google was no different than what Sun did when it sued Microsoft in 1997, because Windows 98 and IE4 did not meet those same compatibility requirements. Sun sued Microsoft for exactly the same reason that Oracle later sued Google. If you were around then and you remember how you felt about that, you were on Sun's side. Professor Samuelson is right, we've gone back. But we've gone back even further in time. We've gone back to the original 1980 enactment of copyrightability of software. That was a decision Congress made. And Professor Samuelson and those who promote the view that APIs and other forms of software are not copyrightable are trying to undo a decision that Congress has made that has caused this industry to flourish. The Ninth Circuit never ruled that APIs weren't copyrightable. The Ninth Circuit never ruled that structure, sequence, and organization isn't copyrightable. To the contrary, software is treated the same way that other literary works are. And if you think about it, the detailed plot of a novel is something that you can't just steal and write a new novel. And that's really what we're talking about, is the detailed plot of a novel in code. Now, functionality. I brought a prop. Can you see the prop? I'm going to stand up. It's a lamp. The very famous Supreme Court case about a lamp like this called Mazer versus Stein, in which the court said that you cannot protect the function of this lamp with copyright. You can't get a monopoly on having a brass lamp with a base and a spindle and a socket. But you can protect the particular expression of the base of this lamp. That is separable from its function. And the same is true of the APIs that were at issue here. Something can be both expressive and functional at the same time. And the limitation on copyright means you don't get a monopoly to, for example, have a method of opening a secure socket connection. You don't get a monopoly on a general method. That's for patent law. But you do get your particular way of doing it, your particular expression. And in fact, these APIs were highly expressive. That's why they're so great. That's why everybody loves them so much, because so much extraordinary care and thought and expression was put into it, because they're intuitive to use. And that is the essence of expressiveness, not function.
Everybody's chomped at the bit. I was going to say, Larry, I'm going to let you go, but then we're going to move on because we've got.
My God.
You guys make your points. We have so much other ground to cover about what other procedural stuff. You'll get a chance to make your points probably in the context of the answers that you tried to ask.
I'll be best.
Okay.
First of all, I want to point out that the socket into which the light is screwed into that lamp is an API. It's not the function of the design. We don't give a damn what that thing looks like. We only care that we can screw a light in it, and it's a light that can be made by any manufacturer, and it will work in that lamp. That's the difference between an API and a design. I also want to point out that Oracle is a very big company, and they have people with different ideas in it. So the views that may be expressed may be Larry Ellison's, but not necessarily everyone. So, for example, within Oracle,
Let's not sing the ad hominem
I'm
attack.
not going to go ad hominem, but within Oracle, there was a discussion related to what was going on in W3C about the license that W3C should use for its specifications. And the option that we chose, that was supported by virtually every member of the committee, was that the specification itself was going to be copyrighted, and no one was going to be allowed to copy the specification as a specification. But in order for open source to be able to implement every W3C specification, it was essential that the license says, not only can you implement it, but you can fork it. You can do with an open source license with this specification what you can do with any open source software. Meaning if you don't like the spec, write your own software, but you better not write your own spec. Or if you do, you better not copy the spec as a spec. That's the difference. And it is a subtle but extremely important difference with respect to APIs.
Okay. On that note, I want to move on because we just have so much ground to cover. We can spend 2 or 3 hours on this, and I don't want
Easily.
I don't want it to turn into a big fight up here on stage. Bloodbath. Let's talk about what the legal proceedings are next. Okay, so the appellate court remanded the fair use issue back to the circuit court. District court, I'm sorry. And so that issue is going back to the district court. There is also the chance of an en banc proceeding. There's all sorts of things that can happen next. So,
Maybe Professor Samuelson.
yes.
Okay.
So maybe you can just tell us
So here's
legally
here's what the options are. So one option is the Oracle v. Google decision was rendered by 3 judges. There are a larger number of judges on that particular court of appeals than those 3 people. So one of the things you can do is you can ask the court.
You being Oracle, I mean
Yeah.
Google. Google
Yes,
would ask.
Google could ask the full court to hear the case again, and then if that was granted, then there would be a new round of briefs and a new argument set, and ultimately some decision coming out of the full Court of Appeals in response to this. So that's one possibility.
And
Another,
when did that happen? What's the time frame for something like that?
so it would happen sometime this summer, probably. The timing issues are partly set by the courts, but sometimes parties ask for an extra period of time to decide things. So I don't know what the timing is on that. Actually, Annette probably knows more than I do on that specific thing. But that's one of the options. Another option is actually to ask the U.S. Supreme Court to hear an appeal from the 3-judge ruling.
I just want to do, these 2 options you're discussing come before it goes back, like, what's the order of?
You can, it's one of those things where you can go back to the trial court, do the fair use issue, but I think that you can ask for the en banc review, ask for the Supreme Court, and then whatever the Supreme Court decides, it is likely to go back to the lower court unless the Supreme Court reversed the Federal Circuit, which it's been doing a lot lately, and so that's an interesting aspect of this.
This is a little easier, I just want to make it clear. Whatever en banc means, we go from the 3 judges that
to all the judges that are sitting on the Federal Circuit.
Okay.
And then, you can petition the Supreme Court to take the case. It doesn't take that many cases, but it's been taking a lot of cases by this particular Court of Appeals, the Court of Appeals for the Federal Circuit, and in almost every one of the cases they reverse. So that's been an interesting thing, although at this case that are similar to the issues in a case, Lovis v. Borland, where the Supreme Court split 4-4 back in 1995, I think it was, or 6. So it's possible that the Supreme Court will also be interested in taking the case because they didn't resolve the Lovis v. Borland issue back then. So those are some of the options, and of course, it's possible also to settle, although I'm not really expecting that in this case.
Fair use. When I think API, I think, okay, that's one line of code. Like, to me, it's the call that you make that invokes a whole bunch of other, APIs are designed to obscure a whole bunch of other stuff, right? We heard yesterday from various API providers that the amount of complexity they obscure behind one API is significant. But it's all
Complexity has nothing to do with
sure.
copyrightability or fair use or any of the other.
Well, what I'm getting at is if you make a call to that complex function with one line of code, and I think about what fair use has meant to me as a journalist over many years, there's like, okay, depending on where you work as a journalist, you can take 10% of the text of somebody else's article and incorporate it into yours, as long as you give credit, 15, 5, there's an argument over what it really is. Nobody, unless you copy the whole thing, nobody really makes us think about it. But if it's just one line of code, can the same rules, what is fair use of an API?
It's an aside question you're asking. There's 6,000 lines of code.
7,000.
7,000 lines of code. So let's not argue about whether a bubble sort is copyrightable.
Well, part of the reason I'm asking this question is because in the web API world, they're a little bit different from Java APIs. This is the way web APIs work.
The analysis of fair use looks at the work and looks at the use of the work and looks at how it was intended to be used and what the effect is of that so-called fair use. So independent of whether it's 7,000 lines of code or 7 million lines of code, depends on what the uses are. And here's the analysis. You're supposed to, there are 4 factors for fair use. The purpose and character of the use. Well, if we define the use as a specification for people to implement software, then the purpose and character of the use is exactly what Sun and Oracle wanted. If we say the second factor, the nature of the copyrighted work, it is an API, it is a spec. And if we treat the nature of the work as being not 7,000 lines of software, but rather instructions for how to write software, even though it has code in it, then it would seem to me that the nature of copyrighted work is such that the fair use factor would be in our favor, or Google's favor in this case. The amount and substantiality of the portion used, that's the third factor. And quite frankly, they used it all, right?
Well, they used 37 of 160 packages.
Okay, but they were supposed to. They were told, make it compatible. And the final factor is the effect on the potential market. How in the world is Sun or Oracle hurt by having more people write APIs in Java? In fact, that's what they want. Write once, run anywhere.
All right, go ahead.
So, this is a great discussion. Okay, so engineers, especially, and journalists, and everybody wants a percentage that counts as fair use. David, I totally hear you, right? Documentarians, everybody always wants, there's the 10% rule of thumb.
We just want guidelines. We want a guideline so we know we're not going to get sued.
All right, so here's your guideline. A private, non-commercial use is almost always going to be fair, okay? That's why, in another case I'm working on right now for Dish, we're making the world safe for commercial skipping on your DVRs, If you're doing it in the privacy of your own home for non-commercial reasons, Sony and other cases say it's going to be fair, right? But when you're doing it for commercial purposes, and you're harming the markets or the incipient markets or the potential markets for the original work, that's the definition of unfair. That's the very definition of an unfair use, All right, so when we ask about the purpose and character of the use, that's right, that's the first factor. The single most important aspect of that is whether the use was commercial or not. And of course it was commercial here. Of course it was a commercial use. To develop a commercial application to be sold in order to maintain and improve Google's position in mobile search. Its purpose could not have been more commercial. I'm going to focus on two of the factors. The fourth factor and the first factor. That's the first factor. The fourth factor is those are the two most important factors. The fourth factor is whether the use harms the market for the original or its derivatives. Before Android, we had licenses. There were licenses from Sun or Oracle to BlackBerry, Kindle, a variety of other commercial applications, including in the smartphone or feature phone and tablet space. Now, none. By definition, all those things that have moved over to Android that were once using a Java platform to develop those applications are the kind of harm that historically has always been considered unfair in the fair use analysis. Now, the answer that many of my colleagues on the other side have offered is, well, interoperability, we need interoperability for fair use. And certainly those are the cases to which Professor Samuelson referred, the Sega and Sony cases where the courts held that interoperability was an important factor. So what do we have here? We don't have interoperability. Android's not backwards compatible with the Java platform. Those applications don't work with each other. So even if interoperability were an important factor where you have a commercial purpose and you've destroyed the market for the original work, it's not present here as a factual matter.
Okay, you referred to the difference earlier, or the lack of differences between the case where Sun sued Microsoft and Oracle sued Google.
I said what was at stake was similar in both cases.
Similar, but maybe I have the timing wrong. But if I recall, at the time that Sun sued Microsoft, Java was not open sourced. But at the time that Oracle sued Google, Jonathan Schwartz, by that point, who was the former CEO of Sun, had led a very painful effort inside of Sun, hotly contested debate to open source Java. At which point, did that not make the fork that Google created both legal and feasible, so long as they contributed their code back to the open source community?
At any time, Google could have agreed to take a license on the terms for which others were offered license, which the key element of which is not present here, is compatibility. And that was the key element at stake in Sun versus Microsoft as well. If you read the early opinions, there was an injunction granted, and the key element of the license offered in that case that was not met was compatibility.
But did Sun give up on work when Sun open sourced?
Did it give its right to insist on compatibility? No. Because when you license, you can put conditions into the license, and it's a common and basic condition in open source licensing that you give the code back that you create that's based on and part of the underlying open source code. And if you think about it economically, that's the only way open source can really work. Otherwise, people are always giving everything away for free without any prospect of return, even in a services economy. Those improvements come back. Or you pay for it. You pay for the right not to give them back.
Listen, be careful what you say, Larry, because I noticed you cut.
She didn't.
Really rip that.
I didn't do it.
There's some factual problems here that I want to clear up.
And then I want to get a word in it.
Yeah, absolutely.
The